Today I speak to you as the Deputy Chief of the Vancouver Police Department Investigation Division, but also as a member of the Canadian Association of Chiefs of Police, and I'm very pleased to be joined by Tom Stamatakis, President of the Vancouver Police Union and the Canadian Police Association. The Canadian Association of Chiefs of Police, or CACP, is asking Canadians to consider the views of law enforcement as they debate what we refer to as lawful access, or Bill C-30, to enact the Investigating and Preventing Criminal Electronic Communications Act, and to amend the Criminal Code and other acts. This bill was introduced by government last week, and it has generated much controversy. There's no doubt that the bill is complex, and the technology it refers to can be complex as well. I would, however, like to provide some understanding of the bill from a police perspective. We believe the new legislation will assist the police with the necessary tools to investigate crimes while balancing, if not strengthening, the privacy rights for Canadians through the addition of oversight not currently in place. It will help law enforcement investigate and apprehend those who are involved in criminal activity while using new technologies to avoid apprehension due to outdated laws and technology. It will allow for timely and consistent access to basic information to assist in investigations of criminal activity and other police duties in serving the public. Things like preventing suicides and notifying next of kin. The global internet, cellular phones, and social media have been widely adopted and enjoyed by Canadians, young and old. Many of us have been affected by computer viruses, spam increasingly, bank fraud, and credit card fraud. These new technologies are also being used as a safe haven for serious criminal activity, identity theft, child and sexual exploitation, gangs, organized crime, and national security threats. This is a huge challenge facing law enforcement agencies. We collectively need every reasonable tool to prevent such activity from happening in the first place, and to investigate and lay charges when it does. We also need the privacy safeguards to ensure we're accountable in the use of these tools, and we believe Bill C-30 provides just that. The current legislation in the Criminal Code regarding lawful access was drafted in 1975, in the days of the rotary phone. The proposed legislation will help the police deal with today's technological challenges that face law enforcement, and in some cases, hamper our ability to protect the public. This legislation can be broken down into three main areas. First, there are the sections around intercept capability. What this deals with is the fact that there are some telecommunications service providers who are in business in Canada who do not have the technological ability to provide information to the police upon lawful request or with warrant. What that means is that the police could go to one of these providers with a warrant to intercept telephone calls in a kidnapping investigation, and the provider doesn't have the capability to allow us to do that. This bill would require all telecommunications service providers, or TSPs, to have necessary infrastructure to allow police to get the data or intercepts they need when the police are lawfully allowed to do so, and lives could depend on this. Secondly, the matter of basic subscriber information is very sensitive. The information which companies would be compelled to release would be name, address, phone number, email address, internet protocol address, and the name of the service provider to police who are in the lawful execution of their duties. While this information is important to police in all types of investigations, it can be critical in cases where it is urgent that police locate a caller or original of information that reasonably causes the police to suspect that someone's safety may be at risk. Without this information, the police may not be able to quickly locate and help the person who is in trouble or being victimized. An example would be a message over the internet indicating someone was contemplating suicide, where all we had was an email address. But we want to find and help that person as quick as we can, and we'll need the basic subscriber information. Currently, there's no audited process for law enforcement to gain access to basic subscriber information. In some cases, internet service providers provide the information to police voluntarily. Others will not, or often there are lengthy delays. The problem is that there is no consistency in providing this information to police nationally. The RCMP's National Child Exploitation Center states in 2010 the average response time for these requests was 13 days. During this time, victims could continue to be victimized. Currently, law enforcement agencies are not directly accountable for these requests and for information they obtain. Under the proposed legislation, new safeguards will be implemented which actually enhance the privacy of Canadians. These include strict limits on the number of law enforcement officials permitted to request information, the training of such individuals, strict procedures for recording, reporting, and auditing of such requests, and the implementation of an auditing and reporting process which includes providing documentation to public safety ministers, privacy commissioners, and federal and provincial authorities. Lastly, one of the most important things to remember, this bill does not allow the police to monitor emails, phone calls, or internet surfing at will without a warrant, as has been implied or explicitly stated. There is no doubt that those who are against the legislation may want you to believe that it does. Let me be clear, that does not exist in the legislation. We still need a warrant. There are no changes in this area from current legislation. The new bill does require that upon request of a police officer, a telecommunications service provider must freeze data for 21 days while police get a warrant to examine that data. This is tremendously important as it does take time to get a warrant, and the preservation of data, preventing it from being erased, can be critical to catching a criminal. There is nothing in the bill that authorizes the police to ask the provider to specifically monitor the traffic of the individual and report back to the law enforcement agency on the activity of an individual. It is not a collection order. It is to freeze existing data. While it provides authority for the police to obtain basic subscriber information in the course of their duties, access to email and internet activity is only available with a warrant, as is the case now. This legislation is important to enhance the ability for police in Canada to investigate crime and prevent victimization. Our hope is that members of Parliament, the media, and Canadians as a whole will take the time to view this legislation through the lens of law enforcement. The debate, balancing community safety and privacy rights, is a debate which must occur, and we are very mindful and respectful of the views of all Canadians. The CACP, however, is disappointed in the amount of misinformation and rhetoric that is clouding an important discussion on this issue. Other police officials from across the country will be providing comment in the coming days as well. And I hope I've provided some clarification, and I'd be happy to take any questions that you might have.
Who decides who taps in? Is it you that decides? Who gets to decide who taps in?
Who taps into a phone?
So if you decide, the police, a judge does.
Yes.
So it needs a warrant regardless?
Right. The only time that the police can tap into a phone or put a wiretap up is in an exigent circumstance. And I'll give you an idea of that. If a kidnapping was to happen at this very moment, and we had a phone number for one of the suspects or the victims in that, we could start tapping that phone right away. But as soon as we do that, there are restrictions put in place in the criminal code about reporting it to a judge, about writing a warrant right away, and about doing certain things that hold us accountable. So when it's a life safety issue and we need to do that right now, we do have that ability. It's done rarely, but we are held accountable.
So what happens if you tap into someone who's innocent, who shouldn't have been tapped in the first place?
We can't listen to the call.
Sorry?
We cannot listen to the call.
So I don't understand then, what's the point of
so we'll get technical. We're going to start getting technical on this. We can only listen to calls that would apply to the investigation that we're doing. So if we're listening to somebody, if we have a warrant and we tap somebody's phone, and a conversation is going on between two people in the house that are unrelated to the investigation, we can't listen to it.
All right, so the ones you do listen to,
yes.
What happens if you listen to somebody who's innocent?
Well,
who had nothing to do with it whatsoever?
First of all, if it's again, we're getting really technical, so I think you should probably look at section 184.
No, I just want to know what happens if you do listen to someone who's innocent. What happens then? Do you
We'll listen
tell
to
them
the
that
call,
you've
but it
done?
doesn't become part of the case.
But do you tell
But
them
how do we know if
afterwards
they're
you're listening?
innocent to begin with anyway?
That's just it. How do you know when you're jumping into someone who's innocent who's not?
Okay, so there's two issues here then. First of all, if it's an emergent situation, we're tapping into a phone, we're gonna listen to the conversation. At the end of it, the law requires that we notify the people that we listened to, that we did that.
Okay.
And any evidence that we obtain in those emergency situations is not useful in court. So that protects that. If it's an authorization, yeah, and the information would be sealed, as Tom says, until, unless that information lawfully obtained did get entered into court. When it comes to an authorized wiretap where a judge has authorized it, if it's innocent people that are not involved in the investigation, we don't listen to the information. With regard to examples, you'll see something coming out of the CACP website shortly that will give numerous examples. I'll give you one right now. In December 2010, New Brunswick RCMP began to investigate a case of peer-to-peer sharing of child pornography. Police suspected that up to 170 IP addresses were associated with a single individual. These IP addresses belong to a TSP known for refusing to voluntarily provide subscriber information with a court order, so the police applied for it. And as a result, the basic subscriber information was provided 15 days later. It takes time to write these warrants. And the person had stopped their activity by this time, and the person later on, as in 2011, picked up their activity again. This time they did get the basic subscriber information right away, and the person was arrested and charged with numerous child pornography offenses. I'd like to specifically address the comment that was made about the public having fear about us being able to listen to phone calls or monitor email without warrant. And again, I'll go back to the fact that this is only under exigent circumstances. And let me, if the public was upset about that, or if the public is upset about that, how upset do you think they'd be if a child was kidnapped today and an Amber Alert went out, and all we had was an email address for the person who kidnapped that person? So now we have to write a warrant. And to wiretap that person, to get that warrant, I don't know, 10, 15, 20 days to write? What's the family going to say? I'm sorry, we couldn't get up an emergency wire because we have to write a warrant every single time. Do you think Canadians want that? No. What they want is their police to be responsible and accountable, and to only use these measures that are very invasive of a person's privacy when it's absolutely necessary in a life safety matter. So I ask you to please read section 184, I believe it's 4 of the Criminal Code, because it doesn't say the police can do this every time. We can only do this really when a life is in danger.